Last week, the Attorney General Holder was in front of a committee, basically going over the some of the scandals, including the AP question, and he was asked by Representative Hank Johnson, a Democrat from Georgia, about the notion of prosecuting reporters. And he went on to say, I'm quoting Holder here, "You've got a long way to go to prosecute people, the press, for the publication of that material. This has not fared well in American history. With regard to the potential prosecution of the press for the disclosure of material that is not something that I've ever been involved in, heard, or would think would be a wise policy. The focus should be on those people who break their oath and put the American people at risk, not reporters who gather this information." Now, this was last week. Either Eric Holder was lying or has been completely in the dark as to what his Department of Justice has been doing, and both in regard to WikiLeaks, but also, as the story broke yesterday, in regards to to James Rosen, a Fox News reporter. Tell us about that story of James Rosen.
Okay, so let's start with the WikiLeaks criminal investigation that the Justice Department has been conducting, and by all accounts still is conducting, and that Eric Holder has publicly defended.
And I should just say that
Alexa
O'Brien on Twitter today, as late as today, has reconfirmed that the grand jury is continuing their investigation into WikiLeaks.
Right. This is a criminal investigation to prosecute WikiLeaks for crimes. And what's crucial here to realize is that the analogy that is often made to WikiLeaks, what WikiLeaks did, is to the New York Times publication of the Pentagon Papers, which was leaked by Daniel Ellsberg. And in that case, it was Ellsberg who was the quasi-government official who obtained the information and then gave it to the New York Times, and it was the New York Times acting as the journalistic entity that then published it. The New York Times didn't obtain it, they didn't steal it, they received it from the government source, Daniel Ellsberg. In the case of WikiLeaks, the analogy is not that WikiLeaks is Daniel Ellsberg. Bradley Manning is Daniel Ellsberg. Bradley Manning is the official, the government employee who obtained the classified information. He then passed it on to WikiLeaks, which then published it. WikiLeaks was acting essentially as the New York Times here. They were publishing information that a government source had provided them. WikiLeaks had no obligation to keep that information confidential. They didn't work for the government. They didn't obtain it. They simply received it from their source, just like the New York Times did then, and the New York Times and other newspapers do all the time. And so the question arose for the U.S. government, which is, well, we want to prosecute WikiLeaks, which clearly they do and said they want to do. How is it that we can prosecute WikiLeaks when they really did nothing more than act as news outlets do all the time? They receive classified information from a government source and then publish it. And of course, the New York Times and the newspaper for which I write, The Guardian, and other media outlets also publish that same material that originated from Bradley Manning. And the answer that the Holder Justice Department came up with was to invent this new theory that said, okay, we can't prosecute WikiLeaks simply for publishing this information because that's pure journalistic behavior that's protected by the freedom of the press. It would be too controversial for us to do. So the theory we're going to use is that WikiLeaks did not merely passively receive the classified information. They actively were conspirators in the effort to obtain it. They encouraged Manning to obtain this classified information and disclose it. They plotted with him on how to do it. They set up a secret chat room where Manning could go and pass this information on to WikiLeaks. That they took steps as conspirators with Manning rather than passively receiving the information and then publishing it, and that's what makes them liable criminally for this conduct. And the reason that's such a menacing and radical and dangerous theory is because every single investigative journalist, every single day virtually, does exactly that. It's almost never the case that investigative journalists simply passively receive classified information. Like one day it just shows up in your email box and, oh my, what a surprise, I got a nice little present today, this massive trove of classified information that I'm not now going to write about. It's almost always the case that investigative journalism entails the journalist and the source working together collaboratively. They figure out how they can communicate in secret. They figure out how the information is going to be given in a way that isn't traceable. There's lots of encouragement on the part of the journalist to talk the source into doing it because there's usually fear at the last minute about doing it. So if you adopt the theory that the Justice Department tried to embrace to prosecute WikiLeaks, which is that journalists can be criminally liable as conspirators when they work with government sources to disclose classified information, you're basically rendering all investigative journalism itself criminal. And that was what I was writing at the time that this theory was first disclosed with regard to WikiLeaks, was that if you accept this theory, you're criminalizing investigative journalism. I was urging every journalist to stand up for WikiLeaks if for no other reason than to protect themselves. And it turns out that we now know that exactly what some of us predicted would happen has now happened, which is that the Holder Justice Department has used this theory to label as criminal other people that we consider as sort of mainstream classical journalists. So what was revealed yesterday was that the Justice Department has been prosecuting a State Department advisor, Stephen Kim, because he allegedly told a Fox News journalist, the Washington bureau chief, James Rosen, that intelligence reports have said that if North Korea ends up being sanctioned by the UN, they'll likely respond with nuclear tests, more nuclear tests and protests. Not a very fascinating or dangerous leak, just a way of trying to show the public that North Korea is more dangerous than people think. And so the Justice Department has been investigating and prosecuting Stephen Kim for this leak. And in order to prove that he actually was the leaker, they went to a court, again in secret, and asked the court for a search warrant to obtain the content of the emails of James Rosen for 2 days with everybody, and all of the emails that he ever exchanged with Stephen Kim so that they could read through this journalist's emails. And as part of their search warrant, they needed to demonstrate to the court that there was probable cause to believe that James Rosen had committed a crime. That's the standard they had to meet to get the search warrant. And so what they argued was that not just Stephen Kim, the State Department employee, had committed crimes by disclosing this classified information, but that James Rosen himself, the journalist, had also committed crimes by acting as a co-conspirator with Stephen Kim and the disclosure of the classified information. It used the exact WikiLeaks theory I just described. It said James Rosen encouraged the leaking of the classified information. He arranged for a covert communication scheme. That's what the search warrant called it, whereby they would communicate in secret in a way that wouldn't be detected. And said there's probable cause to believe that James Rosen, the journalist, has violated the Espionage Act by being a co-conspirator in the leak. And that really is a formal declaration by the U.S. government that what investigative journalists do every single day is a serious felony, a serious criminal offense. They're not prosecuting James Rosen yet. He hasn't been indicted. The papers clearly show they were considering that, but it is a formal declaration by the Obama administration that the nuts and bolts of investigative journalism, in their view, is now a criminal offense. And that is, in my view, as critical as I've been of the Obama Justice Department, the single most dangerous thing that they've done to date.
And so how does one square the notion that in this application for a search warrant that was approved by a federal magistrate, we should say, how does one square that with Eric Holder's claiming to Congress that with regard to the potential prosecution of the press for disclosure of material, this is not something I've ever been involved in, heard of, or would think would be a wise policy? I mean, how can you square?
Right.
Is that possible to reconcile those?
Well, first of all, about the search warrant, let me just say that when the government goes to get a search warrant, they go by themselves. There's nobody else present. And especially in national security cases, judges are extremely deferential to the government. This wasn't even a real U.S. district judge. It was just a magistrate judge who doesn't even have life tenure. It's the easiest thing in the world to get a search warrant from a judge when you claim national security. So that really doesn't mean much about the validity. But as far as your specific question about Holder, I would guess that Holder would parse that statement in a very literally legalistic way in order to say that, well, we didn't prosecute James Rosen here. We haven't seriously considered prosecuting him. All we did was tell a court that we believed he engaged in criminal conduct. So when I went into Congress and said that I've never been involved in planning to prosecute journalists or discussing prosecuting journalists, that can be reconciled with what we told this federal court, because even though we labeled him formally as a criminal, we never prosecuted him and never seriously got to the point where we thought we should. And I would guess that would be his reply.
I mean, what's stunning about this is that if you perceive the reporter's actions, if you compare Rosen's actions with that of WikiLeaks and you put it on a spectrum, in fact, it seems to me that it's quite obvious that WikiLeaks was far less involved in the disclosure of what Bradley Manning's information was than Rosen was in the disclosure of what Kim's was. So in many respects, the silence by the press when in regards to the ongoing investigation of WikiLeaks is that much more reprehensible in some respects, because clearly, for I think the advantage of all of us, the press is now sort of woken up with this Rosen case, but it is pretty stunning.
Well, I mean, it's stunning for so many reasons. First of all, there is reporting by James Goodall, who was the general counsel of the New York Times during the papers fights with the Nixon administration over the Pentagon Papers, in which he wrote that after Nixon went to the Supreme Court and tried to restrain the New York Times in advance from publishing the Pentagon Papers, and the Supreme Court rejected that effort, saying the government doesn't have the right of prior restraint in this case under the First Amendment, Nixon became obsessed with prosecuting the New York Times reporter who published the Pentagon Papers, Neil Sheehan. And his theory that the Nixon Justice Department used, or was going to use when they convened the grand jury, was that Sheehan had conspired with Ellsberg to engage in this leak by doing all the things that we've just talked about, creating secret ways of communicating, encouraging Ellsberg to do it, enabling it. So it has been known for so long that this theory was a very dangerous weapon that Richard Nixon tried to create in order to prosecute the New York Times for publishing the Pentagon Papers. So to then sit by and watch the Obama DOJ embrace the same theory as a means of prosecuting WikiLeaks and say nothing about it, except when you're sort of supporting it and encouraging it, is unbelievably self-destructive, aside from all the other reasons why it's grotesque behavior, failing to safeguard First Amendment rights when you're a journalist and the like. It's so glaringly self-threatening, this theory, that to allow it to take root just because you don't like WikiLeaks is incredibly irresponsible and really quite stupid. And, as you say, I mean, the usually journalists are far more involved with their sources than WikiLeaks was with Manning. I mean, the Obama Justice Department, remember, the Obama administration held Manning in such oppressive conditions for so many months. The UN ultimately formally investigated and found that the conditions of his detention were both inhuman and cruel, in their words. And the State Department spokesman P.J. Crowley resigned over it. They were attempting for months to get Manning to implicate WikiLeaks and to say that WikiLeaks was a participant in what he did. And to this day, Manning steadfastly refused to say that. And in fact, in his statement that he made when he pled guilty to many of the charges, he said WikiLeaks essentially didn't have anything to do with the decision I made to go and get these documents and didn't really help me or participate in any way.
In fact, he attempted to give these documents to other news outlets before WikiLeaks.
Right, and they just didn't respond to him or didn't take him seriously. And so you're absolutely right that if WikiLeaks can be held criminally responsible or be the subject of a grand jury investigation for 2 years based on this theory, virtually every investigative reporter at every major media outlet in the United States can be held criminally accountable far more easily than WikiLeaks can under this theory that they allow to take root simply because they have animosity towards WikiLeaks.